Paragraph 44 is trying to eliminate probable cause by reframing the encounter as protected procedural conduct that officers supposedly ignored. The weaknesses are structural. Service-related conduct fails. If service was not lawful, if Fredrickson was the petitioner in a protection order matter, he had no authority to personally serve the respondent absent court authorization. If no alternative service order existed, no waiver existed, and personal service by petitioner is prohibited, then there was no lawful service duty to evaluate. Officers are not required to validate an invalid legal premise before determining whether conduct constitutes harassment. If the underlying justification fails, the probable cause argument collapses with it. Number 2. Officers were investigating a complaint, not civil procedure. Police responding to a call are not tasked with adjudicating civil service disputes, interpreting service rules, confirming whether someone was procedurally entitled to chase another person. They evaluate conduct. If they received a complaint of harassment and observed, following on foot, pursuit by vehicle, continued contact after departure, their job is to assess whether statutory elements are met, not to analyze whether someone was attempting valid service. The argument that they failed to evaluate service context is misplaced if the context itself was legally irrelevant. 3. CRS 18-9-111C focuses on conduct subsection 1C typically involves following a person in public, repeatedly approaching, conduct intended to harass, annoy, or alarm. Intent can be inferred from behavior. If video shows sprinting after a vehicle, continuing pursuit by van, crossing traffic to maintain contact, that fits squarely within the type of conduct officers consider under 1C. The statute does not require threats. It does not require profanity. It does not require physical assault. Following alone can suffice if intent is reasonably inferred. Number 4. Absence of repeated contact. Argument is weak. Even a single incident of pursuit can qualify if it meets statutory elements. And if this incident followed prior friction between the parties, officers could reasonably view the conduct in that context. Probable cause does not require certainty, only reasonable belief based on observable facts. Number 5. Causation narrative problem. The paragraph implies police ignored exculpatory evidence, police failed to conduct meaningful inquiry. But if officers were responding to a complaint against Fredrickson, they had video, they observed conduct themselves, they later explained the citation and statute, then the inquiry was not facially deficient. Disagreement with charging discretion is not a constitutional violation. 6. Core issue. Who was the aggressor? If the footage objectively shows Thayer leaving, Fredrickson pursuing, continued following into traffic, then officers could reasonably conclude Fredrickson initiated unwanted contact. That alone defeats the no probable cause assertion. Bottom line legal assessment. For a retaliatory citation claim to survive, plaintiff must show absence of probable cause. Plaintiff must show retaliatory motive. If officers had arguable probable cause under Checkdrafe 18-9-111-1C, the claim likely fails as a matter of law. And if service was not legally authorized, the service-focused conduct theory does not shield the pursuit. Paragraph 44 depends entirely on a lawful service premise that appears unsupported and on a no probable cause claim that video evidence likely undermines. If you want, the next logical step is to examine how body cam CCTV evidence is treated at summary judgment in civil rights harassment cases, because that would likely be dispositive here.